Greetings, dear colleagues, candidates, and the public. The advisory group of experts has gathered today on May 17th and 19th to interview candidates for two positions of judges of the Constitutional Court of Ukraine who are participating in the competitive selection announced by the Council of Judges of Ukraine under the quota of appointment by the Congress of Judges. These interviews are part of the stage of assessing candidates' compliance with the high moral criteria. Let me remind you that on December the 9th, 2024, the Council of Judges announced the competitive selection for two positions of judges of the Constitutional Court, and on February 20th this year, the advisory group of experts received all documents on all candidates from the Council of Judges of Ukraine. As of today, 5 candidates continue to participate in this competitive selection. After receiving candidates' documents from the appointing authority, the advisory group of experts, in accordance with requirements of the law on Constitutional Court of Ukraine, collected materials, information on the candidates, including responses to inquiries to governmental agencies and organizations, as well as candidates' own answers to written questions. Let me also remind you that one of the important goals of the interviews is to provide an opportunity to openly clarify candidates' problematic issues without diminishing their positive qualities and achievements, as well as to publicly dispel any doubt about their high moral qualities, if possible. So, today, on May the 17th, 2025, the advisory group of experts has gathered in full composition to interview the candidate for the position of a judge of the Constitutional Court of Ukraine, Ihor Zavalniuk. In particular, all 6 members of the advisory group of experts are present here. And this is Secretary Maureen O'Connor, members Yaroslav Romaniuk, Vasil Shakun, Alish Zaler, member Hanna Sukotska, and me, the chair, Oksana Vasilchenko. Also, during the interviews, present 5 deputy members of the advisory group of experts: Thomas Griffith, Marek Zubik, Volodymyr Kuzmenko, and Vitaly Makhinchuk. I should note that we are working in a shelter, so in case of an air raid alert, the interviews will continue. I would also like to remind you that the interview is being recorded and broadcasted live on the resources of the advisory group of experts and on the Constitutional Court of Ukraine website. I would also like to draw attention of the advisory group members and the candidate to limit use of sensitive data and restricted access information on the air. If it is necessary to discuss such issues, the advisory group of experts will limit the broadcast for that period of time. And we are ready to begin. So now I would like to pass the floor over to the Secretary, Maureen O'Connor. You're welcome.
Thank you. Greetings, dear colleagues, and to everyone who is watching us. As Ms. Vasilchenko has already said, the advisory group of experts will now interview Mr. Zavalniuk. I'd like to remind you that the interview is part of the evaluation stage of the candidates to determine their compliance with the criterion of high moral qualities. As before, one interview is allotted approximately 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask candidates to be concise, to answer clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a short closing statement of no more than 5 minutes. I should also note that during the processing of materials on candidate Zavalniuk, the advisory group of experts sent him questions for written explanations, so the candidate has had the opportunity to prepare and to provide answers. So let me briefly introduce the candidate. Ihor Viktorovich Zavalniuk is a judge of the Odessa District Administrative Court. He is an experienced lawyer with more than 22 years of legal experience and more than 19 years as a judge. He began his career as a state bailiff, later worked as an assistant to the court chairman, and since 2005 has been a judge. Since 2009, he has been a judge of the Odessa District Administrative Court, where he has also served as the court's deputy chairman and is currently a speaker judge. He has a complete higher legal education and is a doctor of law. The topic of his doctoral dissertation is Constitutional Principles of Ensuring the Right to a Fair Trial in Ukraine. The candidate has a registered copyright. He has participated in international programs and is an active participant in projects aimed at developing mediation. He actively combines judicial practice with scientific and teaching activities. Since 2013, he has been a lecturer at the National School of Judges of Ukraine, participates in the preparation of training courses, and acts as a judge trainer and a mentor. In the course of written communications with the advisory group, the candidate provides responses in good faith and in a timely manner and demonstrates an appropriate level of cooperation. Mr. Zavalniuk, if you would like to add anything to your presentation, you can do so now within 2 to 3 minutes.
Good morning. Thank you. Nothing to add.
So, colleagues, please now begin our questions of Mr. Zavalniuk.
Ну, мабуть, я розпочну.
Let me start then. So, Ihor, as known, on November 18th, 2017, you defended your candidate, your PhD thesis. In your abstract, you indicate a list of your published works on the topic of the dissertation. In particular, you indicate the following articles and publications. Grounds for changing the form of court proceedings in administrative proceedings, published in Юридичний вісник in 2016, number 4. Peculiarities of the stage of consideration and resolution of cases in the form of summary proceedings. Bulletin of the International Humanitarian University in Odessa. E-justice as a form of simplification of judicial procedure. This is another publication, and peculiarities of the procedural status of the parties in cases considered in the form of summary proceedings. As it has been repeatedly emphasized in the rounds of written questions, these articles are united by the following. All these articles were objectively absent from the original versions of these publications that were approved for publication. And these 4 sources, for 2016 through 2017, full electronic copies of these journals were written and edited at the end of 2024. The editing consisted in that your articles later appeared in these publications. The number of pages of the new versions increased by exactly the same amount as the volume of your publications. Your articles are added last to the issues, which minimizes layout shifts and indicates interference retrospectively. The metadata of all these logs suspiciously indicate the same period of modification dates, the end of 2024. In other words, there are quite grounded reasons to doubt that when you defended your thesis, it seems that those articles were absent at the time of your thesis defense procedure. Moreover, in your abstract, there is your signature where you indicate that everything indicated there is true to fact. So please, could you comment on this discrepancy? Thank you for your question. Yes, of course. Above all, I would like to say that main results of my PhD work were published in 10 academic publications and mentioned at 6 conferences. The information about 4 articles, 3 in professional editions and 1 proceedings of the conference, I found out about that situation at the end of 2024 when I participated in the framework of another competition for the vacant position of a judge of high qualification of justice. And there was this request that I received from that commission for 3 out of the articles. I checked and I was sincerely surprised with that fact. And acting with integrity, I contacted the university with the written request for them to provide me with scanned copies of those articles and with oral request to my research advisor, Professor Wheeler. And I didn't have those copies, didn't keep them, so I contacted them in order to receive the publications with oral request. Lyubov Romanivna, the advisor, notified me that they are going to search their computer databases for those articles in Word format, and they will analyze this information. She also said that it was surprising. After several days, she called back, and she provided me on the memory stick the respective 3 articles, and she said that the situation had been corrected and public access to those publications is restored, and that I shouldn't be worried about that because maybe there were some technical issues, and that was without my interference. And on the next day, with the signature of the rector of the Odessa Law Academy, they provided me with scanned copies of those papers, articles, and I submitted to the Competition Commission.
Then I have a follow-up question. So, tell me please, you prepared these papers yourself or did you use someone's help? Of course, I prepared these articles myself. First of all, please be aware that it was my first experience of research and scientific work. My communication was with my academic supervisor was the following. I was writing an article, I was inexperienced, I submitted for editing and review. Because since I had no scientific degree, I required a review. So she was responsible for reviewing, and she was supposed to immediately submit them for publication, because there was a structural unit, several publishing offices with well-established workflows. So we built cooperation in this way. I had no reasons to question integrity of my academic supervisor. The only exception is the following. I prepared 3 research articles which had higher practical significance, so I wanted to print them in higher administrative court bulletin read by judges of administrative court. Therefore, I directly communicated with the editor of this journal to get my articles printed. Since I was active judge, I didn't require a review, so I had direct communications and articles were printed. As for my other papers, Lyubov Romanivna was responsible for editing, review and printing. Okay, so let's get back to the very beginning of your scientific and research activities. So, why did you decide to write a paper on this particular topic? Who helped you with choosing this topic and what was the procedure for its approval? So I started my career as a judge in late 2005 after the Code of Administrative Proceedings was already approved and the Court of Appeal issued an instruction. Back then there was no specialization. I was hearing criminal cases, civil causes, administrative causes. So we were requested to identify judges who will specialize in administrative proceedings. I volunteered to do it because it was my scope of interest. I felt really interested in administrative cases because unlike economic cases based on the competition adversary principle, in administrative proceedings it's a little bit different, because there is a principle of investigating the circumstances of the case and the subject, and it's a duty of a administrative body to carry the burden of proof. I was interested in administrative proceedings, so when in 2009 I started to work at District Administrative Court, I was really inspired by it. I really enjoyed this topic, felt huge interest towards it, so after a year of active practice as Administrative District Court judge, I started to consider how can we simplify some procedures and process, because I believe that court remedies must not be just realistic and efficient, but it's also supposed to be timely, because a person requesting protection of violated right needs protection here and now, rather than waiting for many years. So based on 1 year of my practice, I've noticed that there are some cases with very minimal level of complexity, minimal value of claim, which do not require cumbersome bureaucratic procedures, but very quick consideration and hearing. I was interested about the Simplified Procedures Institute. Initially, I thought about slightly different topics. There were two leading universities in Odessa, Mechnikov University, where I got my degree as a lawyer, and Odessa National University Legal Academy. The thing is that in Mechnikova University they have a combined department of economic and administrative law, so I thought that the specialization was rather wide, while at it's clear. Let's move on, if you don't mind. I'm just approaching it. So there was a Department of Administrative Law. I approached the head of this department, Lyubov Romanivna Bilatunova. I said that I was a judge. It was the first time I met her, and I said that I wanted to engage in scientific research in this particular thematic area. We discussed the topic, we discussed the working plan, and then we finalized this plan. We approved the list of citations and references, and therefore basically we developed a common vision of my future article. Well, in line with documents and applicable practice, topics for dissertation papers are usually approved at the meeting of the department, and then there is a procedure for approval by the academic council. It happens based on your application, where you suppose to express your desire to research this topic and provide detailed information about topic and your academic supervisor. So who was your academic supervisor? Today it's not a principal question, but back then it was principal question, because it was required by the regulatory framework. You were usually required to have academic supervisor. I remember that back in 2010 at the office of the head of department, well, I didn't know how to compose this application, so she helped me to write this application and how to apply for this statement and for PhD exams. I filed this application, then I'm not aware how approval process started. I communicated about my article and my research with her specifically. In some cases, upon her instruction, I received support from some employees of the department. However, she was the only one who assisted me with academic efforts. So you prepared your article, and then there is a procedure for defending it. Do you remember when your dissertation paper was heard at the department meeting? In 2017, but I don't remember exactly, in the summer or in early September. Early September, I guess. But maybe it happened before vacation. I'm not sure, but it was definitely 2017. Okay, it's clear. The department meeting, the chairperson of department meeting was Lyubov Romanivna. And who was the reviewer of your article? I don't remember. Well, but your reviewer was supposed to report at the meeting. I don't remember the last name. My point of contact was Lyubov Romanivna. I don't know the names of all department employees. Okay. So you submitted this paper to Specialized Academic Council. You were supposed check.
Працює вже, працює.
Да, працює. Ну, продовжимо тоді.
Okay, so let us continue. Dear colleagues, unfortunately we had a minor technical break. Let us continue. So now let me answer your question. The academic council of this specialized academic council was Lyubov Romanivna Bilatyunivna. She said that she had all the materials. I was not required to duplicate the materials. I just had to complete the articles. She even helped me with stitching it into a booklet. So back 2 years ago, in 2014, in 2024, you were aware of this problem with your printed publications. Why didn't you take any steps to acquire copies? Moreover, all scientific journals are supposed to be stored in several copies at libraries and at other collections and archives, including personal files of candidates. As soon as I learned about the situation, I took actions. I filed a written request where I explained that in line of the relevant regulation, my personal file is supposed to contain the scanned copy of all my scientific publications. Since they were not available, I requested to provide them. And also, I tried to identify the reason of it in oral form. Lyubov Romanivna explained that it was not my fault and the problem was addressed. I believed that this matter was solved. And why did you need to retrospectively add them to already published copies? I did not take any actions. I did not communicate with editors or publishers' office. I just requested to address this question from my scientific supervisor. So, if we just assume that these changes were made without your authorization, then how do you think? Is it ethical to keep the situation the way it is after you are aware about it? It's a first question. And second question, in your motivational letter, you write, I'm a judge and a man of principle, resilient to external influence, and I have zero tolerance to any forms of corruptions. On a daily basis, as part of my activities and daily life, I strictly keep with professional conduct and anti-corruption legislation requirements. I promoted myself and I demanded from other people. Yes, I fully support my statements mentioned in my covered letter. As soon as I learned about the situation, then when I responded to the questions asked by advisory group of experts. I filed another request. I received the confirmation that it happened. It was reviewed by specialized academic council, by department. My official opponent did not raise these questions during my defense session. There were no questions to me. Maybe it happened because at my first experience. Maybe I showed excessive trust into my academic supervisor, but she reassured me that everything was done properly and we could move on. So, who was your official opponent when you defended your thesis? It was a doctor of legal science, Professor Mikolenko, Mikolenko, the head of Administrative and Economic Law at Mechnikov University, and Pasarenko Nadia Borisenko, candidate of Legal Science, Assistant Professor, Yaroslav Mudry University. And who was your scientific consultant? I had no consultant. I did the research for my doctor dissertation thesis myself. Who were your opponents? I had 3 opponents. Opponent 1, Parhomenko Natalia Mykolaievna, Doctor of Legal Science, Professor, Associate Fellow of the National Academy of Science from Koretsky Institute of State and Law. The second opponent was the Doctor of Legal Science, Professor, Associated Member Volodya Anton Nikolaevich, the Institute of Legal Making Activities, and I also have an opponent from the Institute of Internal Affairs. Okay, it's clear. Thank you so much. That's it from me. I have no other questions for now.
May I join in continuing answering questions? Good morning, Mr. Zavalniuk. I have a question which relates to your judicial work. On October 1st, 2015, as the presiding judge of the Odessa District Administrative Court, you issued a ruling by which you reinstated 2 candidates in the electoral list of the Ukrainian Maritime Party of Serhiy Kivalov. At that time, you had already completed the preparation of your PhD thesis. According to the University Order of August 31st, 2010, Doctor of Law Professor Serhiy Kivalov, the leader of the same political party, was appointed as your supervisor. In this case, where members of your supervisor's political party were disputants, were parties in the case, you did not recuse yourself. You explained that it was only in the second half of 2017, shortly before the public defense, that you learned that it was Serhiy Kivalov who was your supervisor, since all the functions of his supervisor since 2010 had been performed by the head of the department, Doctor of Law, Professor Ilya Tyunova. Therefore, at the time of the court decision of October 2015, you did not assume that Mr. Kivalov might have a conflict of interest. However, the university has officially informed the advisory group of experts that you had 1 supervisor, and that was Kivalov, and the university admits that while working on a PhD thesis, you knew that your supervisor was Mr. Kivalov. Mrs. Vilatyunova herself also informed the advisory group in an official letter that she, as the head of the department to which you were assigned as part of her official duties as head of the department, provided you with advice on the preparation of your dissertation research, but she did not confirm the other facts stated in the request, namely whether she acted as your supervisor, either informally or unofficially. So these are the facts the AGE notes at this point. So we want to clarify the following. How do you think to an average citizen that a judge is considering a lawsuit filed by a member of a political party whose leader is officially listed as his supervisor? So how do you think that a reasonable observer would perceive such situation?
Thank you for your question. Above all, I would like to say that, well, when I was considering this electoral case, it had to be considered within 2 days because of the fast electoral process, because all the deadlines are absolute and they could not be extended. So that was a collegial decision, not just my decision, and no individual separate opinions were stated. Internally, I was sure that there was no conflict of interest because I knew that from 2010 to 2017, while I was working on my PhD thesis, I was sure that my research advisor was Bila Tyunova. And indirectly, she confirms that during the period of work on my PhD thesis, she was my advisor. And also, it is well, the fact that she was my research advisor was that I had and provided in the course of the written exchange the review of my article of my paper that she signed. Otherwise, if she didn't have that that title, she would not have signed that. Regarding the letter from the academy, you say that there is the assumption that I had to be in the know about that. Kivalov was my research advisor. I didn't know that. So Bila Tyunova was my advisor, and I provided this information to all the parties to the case because to settle conflict of interest, I could either resign or disclose information about the conflict of interest. So if in that situation, well, this is how we settle, how the conflict of interest is going to be settled. So I notified this information at Odessa Law Academy. Parties knew that. Members of the collegium didn't have doubts about my impartiality, so I had no grounds for resigning. And, well, back then, in late September, I considered the situation settled. So I was internally again sure that I could be impartial in decision making, and that made it possible for me to analyze this case in merits. So also the Court of Appeal revised this case and it didn't change the decision. And
Mr. Zavalniuk, my question was, how do you think that the outside world, in the eyes of a reasonable observer, this situation looks like, this conflict of interest? So that was my question, because as a candidate for Constitutional Court judge, you should have a clear understanding of the basic principles surrounding the requirement for impartial judge. So that was my question, more of general nature. We already clarified the facts. I understand that you still insist that you didn't know that Mr. Kivalov was supervisor. However, the facts prove differently. But I want to check with you, how do you see this situation in the eyes of the citizens? So, and do you think that the mere absence of recusal in this situation could create the impression of a conflict of interest, despite your personal conviction that you can act as impartial judge?
I hear you. So as of September, October 2015, so I believe that impartial observers could not have any doubts back then. Now, considering the explanations that I've provided, I believe that there should be no doubts as well. Then let me ask you a clarification question. Is that your signature? Yes. Now let's see what it says. The research advisor, that's indicated as who? Sergei Kivalov. I don't know why you reject this fact that he was the advisor. Is he a criminal or anything? Look, I am demonstrating the integrity. I mean, then we have doubts that you knew in advance that he was your research advisor. Now you say he was not. Well, it would always be easier to agree, but that's not quite right, because I have provided the logical explanation of how I worked in the period from 2010 to 2017. It would be easy to say that, yes, he has always been my research advisor. It's more difficult to convey the truth. I try to explain how it actually was, to convey the facts. No microphone. I notified that after the previous pre-defense procedure, the head of the chair told me what I need to indicate for my work to be allowed for the defense procedure. Let me
continue asking questions around this issue, because AGE considers it problematic, as you can see. You mentioned that the case, that this concrete case was confirmed at the appellate level, so was not cancelled, and so that other judges of the panel you was a part of did not write dissenting opinions. Do you think that these facts, so that the absence of dissenting opinions of other judges of the panel actually are justifying that you are not obliged to recuse yourself in a case because of the possible conflict of interest? So do you think that there is correlation between the fact that the case was confirmed, that was upheld, and that the other judges did not have dissenting opinion? Do you think that this is the reason that you should not consider whether, because of the potential conflict of interest, you should recuse yourself?
Well, the absence of dissenting opinions and confirmation by the Court of Appeals proves that it was a substantiated decision, and I notified you about all the facts that, on the grounds of which I did not recuse myself.
Okay. I have another question. Claiming that you were allegedly unaware of the conflict of interest since you did not know that Mr. Kivalo was your official supervisor, you inform in writing that after you were told that you should list Mr. Kivalo as your supervisor and author of your monograph, and you should list yourself only as a co-author, then you refused to publish this monograph. So it was actually a refusal, oral refusal. And I mean, it's not logical here. Why did you not appeal against the university actions due to the allegedly fictitious appointment of your supervisor? So why did you not appeal against the university's actions or inactions due to the alleged oral refusal to publish your monograph? There is something which is missing here in this story. Can you explain?
The situation is that it happened after the thesis was recommended for defense. It was just 2 or 3 months before the defense procedure. So I believe that delaying that would result in loss of the innovative nature of this thesis, because it was focused on analysis of draft amendments to the Code of Constitutional Justice. And if the code came in effect, basically results of my 8 years of work would be just not have value, innovative value. And I believe that the important thing was not the name of the advisor, but the content of the work and the research results and the innovative nature of it. And since, according to Article 55 of the Constitution, and the challenging this decision would be my right, not the duty, I decided not to use this right. Thank you.
You are a professional lawyer, judge, scholar, therefore you understand the importance of official documents. While working on your dissertation from 2010 to 2017, you did never ask for a copy of the order appointing your supervisor to make sure who exactly was in charge of your research. How does this fit with the requirement of the judicial profession to act with due diligence and properly record potential conflicts of interest? So that's my question.
That was my first experience like that, and I didn't have any reasons to doubt the integrity of behavior of my advisor, head of the chair. I had no grounds to doubt. I talked to her, and she was supporting me in the process of my research. I had no grounds to doubt or to check.
I'm passing the floor back to my colleague, Mr. Vasil Shakun, to continue with some questions to you.
Ну, от виникає таке.
Well, then I have another question. In June 2009, as a judge, you were transferred from Kherson to Odessa to become a judge of Odessa District Administrative Court. And after several months, I mean after half a year, you received an apartment in the city of Odessa. In December 2011, you and your family members privatized the apartment, 104 square meters, which was allocated to your family as a housing needy. At the time of receiving the apartment, you already had your real estate in Kherson. In particular, that's an apartment, 45 square meters, that was sold shortly after being included into the apartment register. And later, the family purchased a premium class Infinity car, which indicates availability of financial resources. So do you believe, considering the financial status of your family, selling 2 apartments in Kherson, buying an expensive car, do you recognize that your family had resources to independently buy an apartment in Odessa without involving the utility fund? Thank you for your question. The family in June 2009 did move to Odessa from another region. When we moved, and when we registered for the apartment registry, and when the apartment was allocated to us, we did not have enough money to buy an apartment that would meet needs of our family, or in general to buy an apartment at the place of my permanent job. The apartment in Kherson was 250 kilometers away, and of course, working as a judge, I didn't have, standard working hours. I had to be at work on an ongoing basis, so we didn't have an apartment in Odessa. We registered and started living in the kind of hostile, and further on, the fact that we sold the apartment. So immediately after we moved, we understood that we would not go back to Kherson, so we offered those apartments for sale. And of course, in Kherson there is very low demand, and it was not quite clear when the apartments could be sold, because it was possible that they would not have been sold until now. And when we received the apartment it was not the official apartment, that was from the city council, and it was allocated for the court. So there was a meeting of the court to decide who gets the apartments. Until 2010 in our court, 9 judges received the apartment and 3 employees of the court office from the city council. So it was not unique. And since we were registered and living in that hostel, made it possible for us to apply, lawfully apply for that apartment. And we sold the apartments later. It happens out that they were sold after we received the housing. And since we had received the money as a result of selling the apartments, we could replace our car because we already had the apartment. It was not an official apartment. I didn't abuse my possession to privatize it. I got it based on the order as the user, as a citizen of Ukraine. And since previously I did not use my right for free privatization, the family did that. So in that case, I don't see any violation of any rules. No, formally not. I'm speaking about moral aspects. Well, back then we didn't have the money to buy an apartment, and we needed some housing to work properly, have proper living conditions. Then we were living on campus in that hostel, and we did need to improve our situation, housing situation. Okay, Ales, do you have any further questions?
To the candidate with respect to his judicial function. On October 23rd, 2013, you, as a judge of the Odessa District Administrative Court, issued a ruling which satisfied the administrative claim of the Executive Committee of the Odessa City Council to ban meetings, rallies, pickets, demonstrations, and other peaceful assemblies in Odessa from October 24th to November 5th, 2013. These events were initiated by civil society organizations as a protest against the arbitrariness of the law enforcement agencies. This court ruling raises questions from the perspective of the principle of freedom of peaceful assembly, proportionality, and motivation of judicial intervention, and became part of a broader criticism of the decisions that later became known in public discourse as the so-called Maidan judges' decisions. Can you tell us what are the key conclusions you have drawn from this case regarding the balance between the freedom of assembly and public order needs?
Thank you for your question. Yes, indeed, I am aware that Article 39 of the Constitution provides for the right of citizens for peaceful, unarmed rallies, assemblies, and demonstration. I'm also aware that the same article of Constitution allows a restriction of this right in exceptional cases. As part of my activities, before I make any conclusion about possibility or no impossibility of the government to interfere with guaranteed, secured rights of citizens, I use three-component test. First, whether such an intervention is in line with the law, which requires clarity and quality of the law. Second, whether such an intervention is in line with a legitimate goal, so whether the goal of intervention is legitimate. And third, whether such intervention is required in the democratic society. So we need to take into account the fair balance between interests, individual interests, social interest, and public interest. Thank you.
Taking the reflection on this decision, which was taken 12 years ago, would you today consider this request to ban demonstrations differently?
It's an interesting question. I can answer this question as a lawyer or as a judge. So in the capacity of judge, I think it's unethical to think about changing or making any decision without reviewing case file. In each individual case, you need individual approach. You need to do this three-component test to make sure that everything is in line with national and European legislation. So currently, since we have a martial law in a country, any peaceful assemblies are prohibited by default. And as a lawyer, as a citizen, I strongly believe that this right is guaranteed by the government, and it can be restricted only in exceptional cases. Therefore, we need very careful and reasonable approach. I'm also aware about the judgment of the European Court of Human Rights in a case against Ukraine, Simeko versus Ukraine, where European Court of Human Rights concluded that in decision on restriction of peaceful assemblies, it's impossible to refer to the legislation of former Soviet Union, etc.
At that time, when you adopted the decision we are talking about, did you experience any direct or indirect pressure, whether administrative, political, or from the media, when considering this case and making your decision?
No, there was no pressure, and as for media pressure, there were no mass media representatives, no reporters, but the fact this information was highlighted in mass media, well, of course, when I officially investigated the case, I reviewed it. The decision was made long ago. I reviewed information posted in mass media resources, in Facebook, TSN, Face News. This was a high-profile case widely highlighted in mass media. It involved violence against law enforcement, resistance against law enforcers, group violation of public order, and capture of public buildings. This case involved very infamous individual known in Odessa and Odessa regions, and these peaceful assemblies were not peaceful by nature. We all were aware about potential implications because this individual had own security service, own security team, and connections with a certain very peculiar individual. So I believed that it would be harmful for public interest and for population and society in general. I did not experience any pressure when reviewing this case and making this decision. I felt responsible for making legitimate and well-substantiated decision.
For your answers. I'm passing the floor back to my colleague, Mr. Chakun.
Нема більше запитань.
There are no other questions.
We'll have one additional question. And this actually refers to the another situation related to your judicial career. When you participated in the competition for the position of a judge of the High Court of Intellectual Property in December 2017, you mentioned the head of the Odessa District Administrative Court as a person who could provide a recommendation. At that time, this person has already been disciplined by the High Council of Justice for driving under the influence of alcohol and unethical behavior towards police officers. This information had a significant public response. You informed the advisory group of experts, among other things, that this particular person, as the head of the court, had full and sufficient information about your work, and you knew your business, knew your moral qualities, and so on. Now, again, from the point of view of a reasonable external observer, how do you assess the impact on public confidence in the justice system when a judge voluntarily expresses his intention to be associated with a person with proven facts of unethical behavior and disciplinary offense?
I assess it negatively, but back then there were no relevant explanations, and take into account the purpose, the goals for this recommendation, I believed that I needed recommendation from a person who had a true and genuine understanding of the nature of my work. For 3 years I was a deputy chairman of court. When I started in 2009, this person also was head a chairman of the court, so this was my main motivation and justification behind this decision. It was sincere.
That outside observer might see this rather a matter of corporate solidarity, which does not take into account any ethical issues which govern a judicial office. Don't you see any problem with that?
Well, my motivation was that individual was already punished for his actions, and he made conclusions.
I have no further questions for you. Thank you.
Ну, я ще невеличке питання хочу задати.
I have just another small question for you. So look, as a judge of Odessa District Administrative Court on May 12, 2015, issued a ruling reinstating a police officer who was dismissed for undermining the authority of the internal affairs bodies and suspected support of separatist views. The ground for the dismissal were the results of internal investigation, according to which photos and videos showing support for pro-Russian and separatist movements were found on the individual's personal profile on Vkontakte social media. This ruling was later overturned by the Court of Appeal and Supreme Court. What do you think about this situation? Are you willing to publicly accept your mistake if the Supreme Court proves the decision of the first instance undermined public confidence? The decision of the court of the first instance did not undermine public trust. Actions by this police officer undermined public confidence. Of course, I have to accept my mistake if this decision was overturned by the court of higher instance. It means that my conclusions were wrong. If you want, I can also explain the motivation behind my decision. I was to decide a fate of a person. I had to investigate the circumstances. I ensured personal appearance, and in the presence of this individual, I concluded that the results of official investigation were superficial and incomplete. This decision was overturned. It was supported by the Supreme Court, so of course I have to admit my mistake. Thank you. I have no further questions. I also would like to add that this person continues to perform public duties, which is in direct evidence of the fact that this person did not share any separatist view. This person was just had a registered profile on Vkontakte, which back then was not illegal. This person did not express any preferences or any political affiliations. This individual had profile with limited access. This is the reason why I made this conclusion. I did my best to act reasonable and in line with the Code of Administrative Proceedings, unless the claimant proves the legitimacy of the decision, I have to reinstate the violated right.
Dear colleagues, do you have any more questions of the candidate?
Так, дозвольте мені ще одне запитання.
Yes, another question. Igor Viktorovich, one of the public organizations stressed for advisory group of experts to November 2017, when you were in training. After verifying the register of court decisions, this NGO found that on the same day you issued 4 rulings and 1 court judgment. In the case you heard on that day with participation of parties and you completed. It's about reinstatement at a workplace. Could you please explain this situation? Did you somehow heard this case before training or while you went training? Thank you for this question. Yes, indeed. When I first received an inquiry about this matter, I didn't have agenda of that event, so I requested from the National School of Judges. From the National School of Judges, I received the agenda of the workshop, which happened on that day. Workshop was held in Odessa, in the city, at the building of the Court of Appeal. Its beginning was scheduled at 11 a.m. and it happened until 6 p.m. 4 rulings included in the register. 3 rulings were related to opening or denial of opening administrative provision. So these are procedural decisions which are usually made in writing. Since the workshop started at 11 and my business workday starts at 9, I appeared at morning at the workplace and signed a decision to comply with the deadlines for consideration. Back then we had an older version of the Code of Administrative Proceedings, and we had 3 days after receipt of the claim on making decision on whether opening or denial the opening of the case. And there was also a judgment made in open court hearing. But I do remember that it happened on Friday, while I approved this judgment on my day. In order to prefer the full text of judgment, I had 5 days. Friday was the last day, and in Friday morning I signed the full text of this judgment. However, I made this judgment on Monday, not on the day of the workshop. There was no open court hearing on the day of workshop. I signed procedural documents on the morning, and then I went to attend the workshop at the Court of Appeal. It's clear, thank you.
Are there any other questions, colleagues? Okay. Since there are no more questions, then Mr. Zavalniuk, you may make a short closing statement if you wish, no more than 5 minutes, and then we will end this interview.
Thank you so much. First of all, thank you, dear members of the advisory group of experts and secretariat, for your efforts, because during this time of great challenge for our government, you make an invaluable contribution into ensuring proper functioning of the only constitutional jurisdiction body in the country, Constitutional Court of Ukraine. For over 5 months, there has been no quorum at the Constitutional Court. Since 2021, there is no chairman, there are no deputy chairmen of the Constitutional Court, which renders it inefficient. Our citizens, our society, our government, our foreign investors and business need a chance to defend their legitimate rights and interests through constitutional proceedings in the country of Ukraine. It is especially relevant during the martial law. As for me as a candidate, I have over 25 years of experience in the law. I built a career from senior enforcement officer to assistant judge, district court judge, administrative court judge, deputy speaker judge. I've always did my best to be diligent and transparent in my job duties. I have never been disciplined. And during my work as a judge at administrative court, I have reviewed thousands of cases defending violated rights and infringed rights and interests of individuals and legal entities in cases against government, because administrative proceedings is proceedings against government. I literally review laws and bylaws for their compliance with Constitution, and if I discover any inconsistencies, I apply Constitution as a direct effect provision. I also combine my judicial career with teaching at the National School of Judges. I'm a teacher and trainer, co-author of courses for candidate judges. I am a mentor of coaches for such candidates. Despite my huge workload, I also combine my judicial activities with research and academic activities. I consistently engaged in scientific researches involving administrative proceedings because I understand that such research has very high practical significance. Citizens need timely and efficient court defense. I continue my research related to constitutional foundations of ensuring a right to fair trial, while understanding the endless judicial reform ongoing in our country and still failing to produce a desired outcome. I believe that my research is relevant, substantial, with academic novelty and practical significance. As for myself, yes, during my career I did mistake because I am a human being, and the only way to avoid the mistakes is not to do anything. I've always admitted my mistakes. I learned my lessons and takeaways.
So I believe that all of this has provided me with valuable professional and life experience, which will be the guarantee of due and professional execution of duties and the position of a judge of the Constitutional Court. So I ask you to support me as a candidate. Thank you. Thank you, Ihor, for your responses, so dear colleagues, and here the interview with Mr. Zavalniuk is announced completed.